Thank you for being here. Again, my name is Connor Casey. My title for my Graves lecture is Who Decides What's Reasonable? I'm a trial attorney up in Rapid City, South Dakota, an hour and a half north. I, on a day-to-day basis, deal with really the concept of what people think is reasonable. And so I'm going to kind of get into that. We're going to talk about it and analyze it, but really my hope today is that you walk away with a little bit of understanding, a little bit of trust, a little bit of respect, a little bit of hope for what at least one piece of one arm of our government can do. I think it's very common in today's world, regardless of economic position, political ideology, station in life, to feel like the government doesn't serve our interests in some way. And I'm here to tell you, I witness on a day-to-day basis, that I think it does. And it may be in the areas that I encounter, it may be in the areas of civil litigation specifically that we're going to talk about, but my hope is that people should understand that their voice matters, their opinions matter, but more importantly, what matters most is what we can all agree on and what brings us together as a society, as an American society. So it's titled, Who Decides What's Reasonable? We're going to kind of get into what exactly that may mean. I'm from Rapid City originally. I guess I had a fairly unique upbringing. My family started a tourist attraction up there called Bear Country. So I lived with bears for a period of time. People find that interesting. It was an interesting upbringing. I really enjoyed it. It was kind of a unique way to grow up. I would wake up sometimes with certain wildlife drinking out of a kiddie pool in my backyard, lynx, a lot of baby mountain lions, wolves running around in my house. So kind of a cool way to grow up, really. I went to St. Thomas More High School up there, played football, basketball, ran track, and I eventually made my way down to Chadron State. I played football here. I got an undergraduate degree in English and philosophy, and then I stayed longer, worked for the college a little bit, and also got an MBA. I graduated undergrad in 2015, graduated with my master's in 2018, spent a little time studying for law school to get into law school. Eventually ended up in Vermillion, South Dakota. It's the only law school in South Dakota, similar to Nebraska. You got one law school. Great institution, really enjoyed my time there. And while I was there, I became aware that I liked to be on my feet and try and advocate for people. I was a member of the moot court board. There were 7 of us picked out of my grade that would travel around and argue kind of hypothetical arguments before mock judges and mock panels regarding appeal issues. And so I knew at that point I wanted to be involved in some way in the courtroom, because there's all kinds of different types of attorneys, right? I eventually made my way to Beardsley, Jensen & Lee in Rapid City, interned there for 2 summers, loved it. They offered me a job. I've been there ever since. Currently, I'm also on what's called the South Dakota Trial Lawyers Association Board of Governors. And essentially what we attempt to do is preserve a citizen's right to a jury trial, which we're going to be talking about a little bit today. We're involved in lobbying efforts at the legislature. Thank you. We put on seminars, we go to seminars, we represent the interests really of the common person and their constitutional right to a jury trial, which is unique to the United States. What I do, I said complex litigation on this screen. I kind of do a mixed bag of things, and you kind of have to do a mixed bag of things if you want to be a civil attorney in a more rural area like South Dakota, like Nebraska. And so what it really boils down to is I do federal tort claims, which are essentially issues typically involving an injured person. In my life, what I see is on a reservation, whether it's a tribal officer issue or something that happens at a hospital that's funded on the basis of treaty rights. So where a simple issue may appear on the surface, it actually gives rise to more complex issues of immunity and sovereign immunity and treaty rights. We do a little bit of that. I do bad faith insurance. I do a lot of civil rights causes of actions lately. And so really, I'll tell you, what I like to do is something that interests me. If it's a good story, if I like the person who's coming to me with the issue and I feel like it's something that I can help out with. And my firm allows me to do that, which I'm greatly appreciative of. you didn't really think I was going to come and not show you a picture of me playing football here, right? So here's a picture of me playing football, what seems like 25 years ago. One of my former teammates is in the crowd, Austin Stevens. Happy birthday, Austin. This is me, my wife, and my son, Jigs. This is kind of my world right here. And really, my job allows me to be who I am outside of the office, so I'm greatly appreciative of it. This is the place I work. These are the attorneys that I work with. This place was founded before me, it came before me. I walked into it. I'm a very lucky individual in that regards. We have a good mix of a lot of different areas of law, but really, we're really founded on the idea of being a trial lawyer. Now, what that means has changed over time and will change in the next 10 years and 15 years and 20 years. I'll tell you, the guy with the white hair and the tan suit, he's 73 years old. He's tried more cases than I will ever dream to try, because what has happened in the modern world, for good reason, is different types of forums for resolution have kind of come to the surface that are not as adversarial, that are quicker, more efficient, not as costly, not as risky for both parties. And for that very good reason, I won't see as many trials as that man in the tan, but in any event, it's still a very important right that we have as citizens to have a right to a trial when you are accused of something criminally, when you have been wronged in some way. And so this firm that I am lucky enough to be a part of really focuses on that. Helping out where others will not is kind of a hallmark pillar for what we do. So really enjoy being there. So I'm here to talk to you about reasonableness. What the heck does that mean, right? Reasonableness is this squishy, vague term that could mean a number of different things and be subject to subjective interpretations across the board. That's the point, okay? And I'm going to tell you how that framework of reasonableness is actually used across different countries, across different states, counties, cities, to achieve something and use it as a framework to achieve something that a community can all agree on. And so I think it's important to kind of start with these definitions. So the Supreme Court, the United States, I got to have some credibility here. I'm just not making this up. So this is the Supreme Court of the United States says, numerous legal rules hinge on what a reasonable person would think or expect, right? And it touches across many, many doctrines of law. I do a lot of civil law, right? But you can find the concept of reasonableness in what kind of protections are owed to you under the Constitution from invasion from the government, privacy interests, right? Can they just come barge down your door for no reason? Or what kind of level of cause do they have to be able to do that? Or should they just knock? Contract law, if there's not a contract in place, but you're offered a piece of land orally, and there's really no conditions on any of it. Well, what is reasonable for an amount of time to accept that offer, or whether it's or for it to be rescinded? So it goes across many, many different areas. I'm here to talk to you about a few specific ones that I have experience with. In the WEX definition, WEX is simply it's a legal resource. And so this is kind of the legal definition. It means just, rational, appropriate, ordinary, or usual under the circumstances. It's kind of qualifying it. Then this is kind of the common definition, Merriam-Webster definition. Being in accordance with reason, or not extreme or excessive, or moderate or fair. Reasonableness in the law is this living, breathing tool. And it's a framework. But it's also, I'm going to tell you, while powerful, I think flawed in some ways. And it's necessarily flawed for the reasons we're going to talk about. But I think it's important to start with these definitions. Why the heck should I care about this? I appreciate you all coming out. I spoke to a class earlier today. I think a number of you are here. This is important, folks, because reasonableness is used, like I said, it's across many, many different countries. And not only is it across many different countries, is it used as this framework, as this tool to interpret complex issues, it's used in the United States, typically in my life, as a tool for lay people, non-legally trained people, to judge a given issue under certain circumstances. It's important for you to know there's a lot of debate on this issue, right? And really, it's kind of heady academic theory on how should we approach this. Should it be a standard? Is it a community belief? Is it ordinary reasonableness, or is it legal reasonableness? These are all just words, right? And so what it means in real time depends where you're at. That's a lawyer answer, right? It depends. I give that answer a lot because many issues are circumstantial. And that's the point of what's called the reasonable person standard, right? And we're going to get to that, but really what you can think of as a court and eventually potentially a jury is encountered with a number of different situations that are all subjective based on the facts that are presented and the issue that is brought before that court or that jury. Reasonableness is kind of the umbrella that everything has to fall under, and it has to be vague, it has to be flexible, because it has to address a number of different areas that might be an issue that our Constitution, that our laws require to be answered by a jury, by a judge, but by humans. And so why it matters to you here in the United States, in my opinion, is we're the only place in the world where you have a constitutional right to be judged by your community. And that's a serious thing. I do civil rights work, and sometimes some of the issues I encounter are civil issues that result from a criminal procedure where an individual was wrongly accused or had their privacy interests invaded for no good reason, or were indicted on serious criminal charges and then acquitted, or maybe the charges would drop, but it's on the record and we'll never have a job again. Reasonableness comes into the picture because it's trying to get at what's fair. But who decides what's fair? You do. Humans decide what's fair. And that's what the reasonableness framework tries to accomplish. It's a great quote from a great movie, but there is one way in this country in which all men are created equal. There is one human institution that makes a pauper the equal of a Rockefeller, the stupid man the equal of an Einstein, and the ignorant man the equal of any college president. That institution, gentlemen, is a court. It can be the Supreme Court of the United States or the humblest JP court in the land or this honorable court which you serve. Our courts have their faults, as does any human institution, but in this country, our courts are the great levelers. And in our courts, all men are created equal. That's what the court system was designed to do. It's not perfect, right? And this quote kind of gets at that. It's a human experiment. It's the great experiment, James Madison said, right? It's something that is flawed and will always be flawed, but humans are flawed. And the structure of how we govern our society has to be flexible, certain parts of it, right? And reasonableness is one way that it is flexible. So let's just talk about what the standard means. So typically, in my life, a client comes in the door with a certain issue, and what I am considering is, when I get to a jury in this matter, what are those 12 people going to think? And I want to give you kind of an example. There's a four-way stop right out here that you got to take a right to get to the Sandoz Center. There's a difference between legal reasonableness and ordinary reasonableness, all right? I'm going to call it an academic difference because I can tell you as an attorney it doesn't come up. But what it's trying to get at is ordinary reasonableness might be different for somebody who's not legally trained, how they think about a certain situation. I will tell you, when I see things now that I've been in law school and practicing, it's just your mind goes to certain things, all right? Now I have kids, it's even worse, okay? But that's kind of the difference. And legal reasonableness are really these rules that we have agreed on as a society who have eventually become codified. And I'll give you an example, the rules of the road. Stopping at a stop sign, right? Started a long time ago. I'd imagine I'm not here to give you a dissertation on the stop sign. But the point is, we can all agree it's good to stop at a stop sign, right? I think ordinary reasonableness would suggest the same thing. And so if you're going to stop at a stop sign and you blow that stop sign and you hit somebody, I think most people, without any other facts, would say, yeah, you're in the wrong. If that person's injured, you're at fault, right? Let me change the facts a little bit. What if you blew the stop sign because you had a pregnant wife and she's going into labor and it feels like an emergent situation? And yeah, you still hit the person, but maybe you didn't see him. Does that matter? Does that change things? Let me change it a little bit more. What if the pregnant wife who's going to labor is the driver? What if your wife's bleeding out for some reason, or your husband? What if that person's driving? That's why reasonableness exists, because rules, while they should exist and do exist so we can have an organized society where expectations are kind of assumed and you know what's going to happen, you know what to expect, you can't govern all situations, because I will tell you there are certain what are called restatements of law that excuse your noncompliance with a law if you are in danger, if your compliance with the law will put you in danger. And as an added caveat, then you got to prove in that moment, whatever situation you're analyzing with the stop sign and the bleeding or the prank, whatever it is, you have to prove that that was emergent. You have to prove that that was imminent. And that's all going to come down to the question, typically in front of a jury, I'll tell you, hopefully in front of a jury, in most situations, whether something was reasonable. And it's always typically judged under this question, what would an ordinary, careful person do in a similar situation? It's supposed to be flexible. It's intended to be flexible. It's intentionally vague. And so, I like this last quote because I think it gets at it, and it's a little, again, I call it academic, right? Legally deregulated zone in which the many and varied underlying reasons are to be confronted by the decision maker in their ordinary form and applied direct, unmediated by law. It's got to consider everything. It's got to catch all these things, and I want to talk about a couple of examples. If my law school professor knew that I was about to talk to you about this case, he would be shocked and tell me it's the worst idea in the world. So, look, this case, Paul's graph, is what it's known for in legal communities. It's a civil case. And what happened in this case is a long time ago in 1928, right? And what's happening is this individual, Miss Paul's graph, is standing by the platform, and there is, and I'm going to say what was described as essentially a weighing mechanism for luggage, okay? And she's standing there waiting for her train to come, and as that is happening, an individual late to the train has in his hand a suitcase, is running towards the train that's departing, and as that individual gets on the train, with the help of an attendant from the train company, the suitcase drops, and fireworks go off, tips down the scale, and injured Miss Paul's graph, all right? You can see in this picture, it looks a heck of a lot more chaotic than that. However, what's interesting about this case in terms of the reasonableness of it is this case eventually went to a trial and was tried in front of a jury of lay people. That jury found that the railroad was negligent for trying to help that person to get on the train and thus was liable for the injuries to Paul's graph, right? That decision was appealed and went all the way up to the United States Supreme Court, and they threw the verdict out. They threw the verdict out because this concept of what was reasonably foreseeable in that situation, given your operation of a railroad, could not include, if we're talking about reasonableness, that if you try and help someone onto the train, they're going to drop a suitcase full of explosives that's then going to injure this individual over here when a weighing mechanism falls on them. I use this example because it's kind of the cornerstone of a lot of negligence doctrines now in today's world, but I think it's also interesting because it gets at the tension between ordinary reasonableness and legal reasonableness. Legal reasonableness in this situation won the day where the 9 Supreme Court justices said, this is too far. This is too far. It's not reasonably foreseeable. And they actually threw out the ordinary reasonableness interpretation of the issue, in my opinion, the jury verdict, for that decision. And it became a doctrine, right? So it just goes to show this can be used in a number of different ways. It can also be used in the criminal context. The Katz decision kind of contemplated, again, I mentioned it earlier, your reasonable expectation of privacy, which is, I think historically was contemplating locations, your home. I think you expect that you have privacy in your home, and I'll tell you, you're also owed that under the Constitution. There are certain exceptions for that to be intruded. We're not going to go into that, but this case dealt with somebody who was a known gambler who was having a phone call in a public phone booth, and the FBI had a listening device on the outside of the phone booth and caught him making interstate bets. It was illegal. He was eventually convicted for this crime, convicted by lay people. Well, the decision went all the way up to the Supreme Court, and the conviction was thrown out because, again, the Supreme Court at the time found that it is reasonable for you to expect to have privacy within your conversations, absent some exception, absent some sort of cause for the government to intrude on that conversation and catch you, right? And so it can come up in a number of different contexts, and ultimately, what power does it provide? The Constitution starts with 3 words, we the people. And again, if I could go back to where I started, I think we all hope that we are represented on a day-to-day basis at the federal level, at the state level, at the county level, at the city level. And sometimes that feels distant. It feels disconnected. Maybe not for everyone, right? But I've felt that before. And my point with this discussion is reasonableness is an attempt, and I say an attempt intentionally, because it's not perfect, to have power come from the people. Because reasonableness at its core, that I see in front of a jury on a day-to-day basis, typically is me assessing, okay, what are 12 people going to agree on is reasonable and expected, given a certain set of circumstances? What are 12 people going to agree on in terms of what somebody is owed as a matter of right? Could be anything, right? It's intended to catch all those. It's intended to address all those questions. And so I think, in this area, the judiciary is attempting to allow you to put your fingerprint on stuff, albeit by unanimous agreement, typically in South Dakota, right? Many juries, you're required to all agree, okay? Which typically I think is only fair. But you're making law in that moment. And so, I'll skip to the Benjamin Cardozo quote there. He's a Supreme Court justice, former Supreme Court justice, very well known. He's the one who drafted Paul's graph. He's the one who wrote the opinion. The reasonable man is not an individual of exceptional courage, judgment, or foresight. It's just a normal person. But is it a flawed concept? Is it a flawed concept? And is it supposed to be flawed? It's another good quote. If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. I had to do a radio interview last Friday in preparation for this, and it was a great host. But he asked me, he's like, why are you qualified to talk about this, right? And I kind of laughed, because when Alex called me initially, I'm like, I don't know if I'm qualified to come and talk to these people about it. No, I'm just kidding. But look, I'm legally trained, right? Did well enough in law school. I've practiced now for 5 years. I've had jury trials. I've won, I've lost. I think I'm reasonably good at it, okay? But my answer to the guy, I can't remember his name, was the beauty of my discussion is This has nothing to do with my legal education. It has everything to do with what makes us humans, and that's lived experience. I will tell you, I use a lot from my law school education on a day-to-day basis. But I use a lot more from everything that happened to me prior to that moment of me going to law school. My favorite thing about being an attorney and practicing in the areas that I do is that I deal with human beings who come to me with problems, and hopefully they're problems I can solve, and if they are, I take it on. Because I became an attorney to help people ultimately. And that can mean a lot of different things, right? But the beauty of what I do on a day-to-day basis personally is that I am able to help people with the tools that I have that necessarily don't have anything to do with my legal training. And that really comes down to me honestly having to ask the question, what are reasonable people going to think about this person's issue when I drag this to litigation in front of a jury in 3 years? Because that's the question that matters. That's why you matter. That's why we all matter. Because certain parts of the government may not feel like they're working for you, but I will tell you, parts of the judiciary and parts of the court system strive every day to accomplish just that. It may not be perfect. It may not accomplish that, but that is what it's designed to do, and it's a unique aspect of the United States. And so asking the question, is it flawed? Yeah, it absolutely is flawed, because I'm talking about this in front of you in a tie, and I'm acting like when I go in front of a jury, they're only going to hear the facts that I have to say. The judge is going to instruct them on exactly what they can and can't consider. They can't be biased in a certain way, and they only have to judge everything objectively, right? I'm here to tell you that doesn't happen. It doesn't happen. And because of that, I think it's important for us to question this concept, because that's what we do on a daily basis. And I want to talk a little bit about how I've seen it, all right? So a couple things. Typically, when you have a given issue, you're going to get either to a judge to make that decision. If you got to, there's things that happen before that, but let's just talk about it in a vacuum a little bit. The goal is to get in front of a decision maker, whether it's 12 members of your community or a judge or a panel of judges, and that can get complicated, but the whole point is the goal of certain areas of law is to get you to a human being to consider your circumstances, to consider your issues, to consider the arguments of both sides, the accused, the person accusing. And the idea is that these human beings are going to judge your situation. Well, as you can imagine, you going in front of a judge versus you going in front of 12 individual lay people is two different situations. Honestly, highlighted by the case examples I had, right? Where lay people make certain decisions, but then judges reverse the whole thing and throw it out. And I want to talk to you about some specific examples that I've encountered that kind of show why it's important to understand how you're making those decisions. Now, I'll tell you, a lawyer's dream is to sit on a jury. We always get excluded because we're lawyers. I'm also very sober to the fact that every time somebody in my life gets called for jury duty, they call me and ask me, how do I get out of this? I will tell you, you shouldn't. Because the ones who couldn't get out that I know and have went through the process at the end of it, they tell me about how cool it is. And I'm telling you, I'm never going to be able to sit on one because I'm going to get excluded every single time. But it is our dream. It's many of our dreams. And why it matters that I'm telling you to really contemplate how you make decisions in this context and in this vacuum is I've seen decisions made on very kind of flippant, surface level aspects of a case. And I'll tell you, so, part of my work, if we have a case that kind of justifies it and we have an issue that maybe needs to get answered, I'm going to talk about this generally, right? We do focus groups with community members that a lot of it's confidential, but I can talk to you kind of generally about some. I had a case that involved very, very blatant fraud and forgery, all right? And we had to run a focus group on some specific issues. And the feedback that came back was all about the posture of my client, who was a woman, and how she sat while she was testifying. And it colored everything they did. Every aspect of the response that we got, it was colored by that and my mustache. And so you think as an attorney, man, I'm legally trained, I got these juicy facts, it's so interesting, this is it, and that's the feedback you get, right? And it was all couched in, again, the idea of what's reasonable, okay? That was the question before them, were certain actions undertaken reasonable? And instead of, again, you hope, you give them the jury instructions and you tell them, the judge is going to tell you have to follow these, all this stuff, and they just disregard it and talk about things that really, really don't matter. And I've seen it in real life. And we call them war stories, right? So I'm going to talk about a couple. And on that note, that specific example, I can tell you in real time. We had a case that involved the Bret Michaels Band, okay? And it was a show that the Bret Michaels Band did at a certain venue that was responsible for a number of things. And in a nutshell, what it was at this concert, at this specific venue, we had a client, an older woman who enjoyed the Bret Michaels Band, in the second, third row. And what had happened was somebody from the front row in the concert crawled over 2 cement barriers, crawled onto the stage, ran about 30 yards back, and then took about a 30-yard sprint off the stage and nosedived right into my client's head. Severe injury. And the question we were asking was the security provided at this venue reasonable? I'm telling you, there was no security, okay? We lost that case, okay? We got zeroed. And why I'm telling you this is during jury selection, this venue's owner was kind of a public figure, okay? And we did a lot of jury selection, asked a lot of questions about, is this person's, kind of image, everything you know about him going to affect your ability to judge this fairly? Some got excluded, some didn't. We ended up with a jury that all defiantly said, no, it's not going to affect us at all, okay? The moment the jury was out after we lost, they were taking pictures with the guy in the parking lot. So again, it kind of gets at, I'm telling you all this stuff, right? But we're human beings. And sometimes how we make decisions, you may not even know why you're making a decision. But that's the point, right? That's the point of the reasonable umbrella, the reasonable man standard, the reasonable person under similar circumstances, because it's the closest we can get to meeting us, the community, society, where are we at on hopefully what we can agree with. All right, I got one more, and it deals with a slip and fall, all right? We won this one. But we had a landowner who had a property in a fairly metropolitan area, and somebody came and alleged that they slipped, fell, were injured on their property. In this particular jurisdiction, what's required to even get to a jury is that you have what's called an unnatural accumulation of ice, all right? If you cannot prove that you have an unnatural accumulation of ice, a judge is just going to throw your case out. What does that mean? Okay? If you think about what a natural accumulation would mean, all right? It snows and you don't shovel. Side note, I have a lot of issues with why this is even a law in this area, because what it's incentivizing is you not to go out and take care of your sidewalk, essentially. But what it contemplates essentially is an accumulation of snow that results from your behavior, which could be shoveling, which is probably a prudent thing to do, is my point. But regardless, in that situation, it was a sidewalk. This gentleman had shoveled, and this person who came by, again, slipped, fell, was injured, and the jury took 35 minutes, and they found that our clients were not liable. But here's another interesting piece. During jury deliberation, a jury can ask questions if they're confused about something, and then the judge comes in, and the attorneys have to come in, and the judge reads you the question. And they asked if they could write on the jury verdict form that they not only found our client was not negligent, but they thought the lawsuit was ridiculous. Okay? And I find that interesting because, again, in that situation, you kind of have this strange, unnatural accumulation standard to even get to the ordinary person's opinion on this thing. And many judges, I think, in these types of situations, let it go to a jury. But they were so offended by that they actually wanted to find that the guy's position was unreasonable to begin with. So look, I'm here today to talk to you about legal principles. Kind of stale, right? But what I want to tell you is the answer to the question, who decides what's reasonable, is you, ultimately. And while the government can be difficult and confusing, and times can be confusing, just know that a jury trial and the reasonableness standard will forever be, I think, commemorated in common law to allow lay people to make decisions on all kinds of situations, and it's designed to find something that we can all agree on. And I think that's important. So use it wisely. My name's Connor. Thanks for having me. That's all I got.
Be happy to open it up to any questions that you may have for Mr. Casey.
Mr. Casey, did you say earlier that you help people with the tools that you acquired before you went to law school?
I did, yes.
So would you say that reasonableness is based on perception?
Absolutely. Yeah, and that's kind of my point with the examples.
I was doing my best lawyer.
No, you did great. You feel like a judge. No, I think that's the point. And I mean, this country was designed as, again, they call it the great experiment, and we're still experiencing that, I think, in a lot of ways. And my point is, I think we can feel a lot of disconnect. And what I see on a day-to-day basis has nothing to do, it has a lot to do with the fact that I have a JD and I'm legally trained, I have a bar license, I passed exams, blah, 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 right? But really, the area I practice in tries to get human beings to make law, not attorneys, sometimes judges, and there's a lot of contours to what I'm describing, but ultimately, what's so important about a trial, what's so important about a courtroom and what a judge does and what a jury does, and of course, I think what attorneys do in terms of advocacy is to try and get a community to answer a question that they can all agree on. In that decision, we as lawyers think they're going to decide this for this given reason, right? But in reality, it's typically based on exactly what you just described. Their own experience, what they think about something, whether they like my mustache, whether they like somebody's posture. Now, it's my job to communicate why you shouldn't consider those things and actually consider my facts and actually consider my client, even though you may not like their posture while they're testifying. And that's kind of the job we have, which is why, trials are really kind of tenuous, frantic event in a lot of ways, because you just have no idea, right? You think you do. I can tell you that. We thought we were going to win that stage diver concert, you just don't know. But that's kind of the point. That's kind of the point, and I think it's okay that it's flawed, is kind of one of my conclusions, because the rigidness of many laws, many statutes, many things that may apply to you, sometimes are not fair to apply in certain circumstances. And so we need this kind of vague, flexible term, flexible doctrine that can address many, many situations.
The USA perception is fickle, correct?
Say that again. Perception is fickle?
Your perceptions, because everyone here has a different perception on the same situation. Everyone would have a different perception of that because of the way they were raised.
I'd say perception is subjective. I'd agree with that. I think some individuals' perceptions can be fickle, surface level, absolutely. I think others could be the opposite, and be have much more depth to it, And it just depends on an individual's experience. And one thing I mentioned, jury selection, right? Jury selection is designed to root out all the issues. I say it's designed, right? In reality, jury selection can be however long the judge wants it to be. You can have somebody who literally is. I've had situations where I try and exclude a juror because they tell me they're biased because, they had a situation with, one time it was opposing counsel represented an insurance company that screwed somebody over and all this stuff, and they're like, I'm not going to listen to a thing they say, right? And that would have actually been kind of good for me, right? But in that situation, to build credibility and to be fair, because ultimately it would have caused an issue in the long run, you ask that person to get excluded. Well, what happens in that moment is then the judge tries to rehabilitate them, and I'll tell you, what a judge always says is, are you telling me, if at the end of this case, I tell you this is the law and you have to apply it, you're not going to apply it because you don't like that guy? Very few people are going to be like, yeah, judge, I'm not going to listen to a dang thing you say, right? And so, while I understand what you're saying, right? Jury selection is designed to root out maybe some individual's perception that may be fickle, given the facts you're going to present them. But I can tell you in real-world experience, it's hard to do. Depends on the judge, and doesn't work all the time. Good question.
Why did you decide to go to law school?
Yeah, good question. I wanted to help people. Yeah, my mom was very instrumental in my life, still is. She helps a lot of people and has, and in a lot of different ways. And I didn't know how my stubbornness and dry sense of humor and kind of satirical maybe quips that people may find offensive would have any use anywhere. I found out it did. And so I think I have skills that lend to being an attorney, but ultimately I want to use all those things to help people, and that's why I went into it. My dad died untimely, and I also was able to see kind of how the estate proceeding went. Attorney helped us through, and he did an unbelievable job, and I thought, hey, I want to do that. Yeah. A lot of different reasons you can get a JD, though. Yeah. A lot of different jobs. Yeah.
A lot of us are in the law program, and so we're looking to go practice in more rural areas. And I know that practicing in Nebraska, jury trial can be kind of a big deal out there. Do you have any advice or criticisms or critiques on the current systems where in rural Nebraska, chances are you know that person from church or you know that person from anywhere, and do you have any critiques on that current system, or would you rather embrace that bias?
I think so. One, if you're going to do, when you say rural law, that to me that can mean a couple different things. So I'll address one of them. So USD now has kind of a similar program where there's a great need for attorneys in rural areas, desolate areas. And part of the program is you're tied to a mentor. So my point is really good mentorship because, like I said, the firm I was at was founded in 1997. I walked into this. They taught me. They spoon-fed me. You know what I mean? I didn't invent all this stuff. So I think that's number one. And number two, and I told the class this earlier, and I think you'll experience it here too, because I assume many of you are eventually going to make it to Lincoln. I think South Dakota and Nebraska are similar in a number of ways. And one of the ways they're similar is the Bar Association of Attorneys is very small. And so in communities and with your peers, it becomes very important that you're credible, you're honest, but also that you're kind. because what you will find in law school is it's very competitive, it's very cutthroat. You're often fighting for 0.2 of a grade point that may get you 10 more spots in your class rank, that's going to get you an internship that's X amount higher paid and better placement. And so it can become a place where you think the best thing to do is to step on heads. I will advise against that. My law school class was pretty tight, pretty civil, but I also saw the opposite, and that stays with you. It stays with you. It's already hard enough what we do for both sides, and so it's adversarial by nature. So good mentorship, be kind, and there's no substitute for hard work. Seriously. And I mean that because I didn't graduate number 1 in my class. Did well enough, right? But if you work hard, sweat equity is a real thing. It's a real thing. So, good question.
You spoke briefly about just the general person's perception that they're not represented by the government and in the court system. Do you think that affects how your jury trials go? In your experience, has people's perception of the government or the court system changed?
Yeah, I think so. I think it's and this is something kind of talked about at some of the trial lawyers, the South Dakota Trial Lawyers Association we go to. There's definitely what we see and encounter. Again, I'd call it a disconnect or a belief that the rule of law kind of doesn't matter in some contexts. How that comes down to jury trial is kind of like what I described. The judge is going to tell you have to follow a rule, and then you don't follow it. Now, again, some of that can be rooted out before by empowering jurors. If you're back there and a member of the jury is going to say, I know this is what the jury instruction says, but I don't care. You're required to come to the judge, But definitely see it. How it's kind of confronted is something I don't really have an answer for. And part of the reason I wanted to talk about this, because I believe in what I do, of course, right? But I do think it is, again, striving to be as close to what we can all agree on as possible in a lot of different ways, where maybe the political process that gets lost, along the way. Good question. Yes, Alex.
As an undergrad at CSC, similar to many in the audience, talk a little bit about your undergraduate experience and how that prepared you well for law school and for your MBA.
Okay, yeah. So there was no RLAP program. There was a legal studies program here when I was here. I graduated in 2015. I think the RLAP program probably started right after that-ish. So I came here intending to study history. I thought I wanted to be an attorney. Didn't really know. And what I eventually ended up with was English and philosophy. So here's what I'll tell you. Every single day, I critically analyze something and I write. Okay? Now, that's not every area of law, but I will tell you, if you litigate, if you're in motions practice, if you're confronting kind of what I'm describing with civil issues, you're going to be required to do those things a lot. And so I think that the most important thing, I got a lot of things from this place, but the most important thing I got from it was an ability to write and an ability to think critically. And those things developed over time as well. But I think whatever you're going to pursue to prepare for law school, I think at least some aspects of your learning should touch upon those things. Because I'll also tell you kind of the other side of it, because I sat in the class today, and it's wonderful to see the areas you all are learning before you even get to law school. Law school is only 3 years. Med school, I don't even know how long it is at this point, right? It's like a long time, all right? But I will tell you, one of the issues that I see and that I encountered was getting out, kind of the practical day-to-day was difficult to kind of absorb and learn. I had to kind of learn how to talk to a client, talk about an agreement, stuff like that. I understood the legalese that would be spit at me in Latin in a case law book, but kind of the day-to-day stuff was difficult. You guys are learning that right now, and I think that's amazing because law school is only 3 years, it's going to be a lot of doctrinal theory and case law interpretation, and professors are going to put you on the spot and make you recite a case in front of your class and try and like get you rattled. But I think it's important that you get that stuff right, but you also kind of foster your ability to critically think, to write, because I think you're going to be doing that no matter what you're going to be doing as a lawyer, quite frankly. And then the MBA was fantastic as well. I mean, again, at that point in time, I thought I was going to be like a corporate attorney, I think back then. I'm very far away from that now. And so, I aspired for the MBA, I think for that reason, which, again, I also do some business law. And so that's really been informative on that end. But look, I love this place. Alex knows I'm a homer, and so does Austin, and now Daniel probably does too. But this place, you're lucky because this place is unique, and it'll give you the tools to walk forward and do whatever you want to do in a lot of different ways. So value it. It goes by quick. Good question, Alex.